Bonsoir, Madame, Monsieur. Je m'appelle Toshiko Takenaka. Je suis désolé de ne pas pouvoir participer à la conférence. C'est un grand honneur de faire une présentation. When I started to study intellectual property law in 1980, I was told that territoriality principle was one of the most important principles for controlling intellectual property rights. At that time, there was no internet, no smartphone, or personal computer. As indicated in this slide, the third industrial revolution began in 1969 with the invention of computers, which automated manufacturing processes. Since then, computers are getting smaller and smaller and disseminated throughout the world. Nowadays, even preschool age kids carry small computers called smartphones and get connected with their parents and teachers. Europeans call this current trend of hyper-connected society and economy Industry 4.0. Under this new trend, businesses and innovative activities go beyond the boundary of companies as well as the boundary of a country to engage open innovations. IP owners who engage open innovations use patents and copyrights to share their technologies instead of excluding others. A good example is open source and patent common activities. Researchers in Lyon work with researchers in Seattle or Tokyo to develop an invention and a work of authorship. To provide hyperlinks between human and things for engaging innovations, software and industry standards play a very important role. A term similar to Industry 4.0, but more popular in the United States, is information age, where intangible object such as information or software has more value than tangible object such as a machine or hardware. In Bielski, the U.S. Supreme Court reviewed patent eligibility of software patents. Although the court affirmed the rejection of patentability regarding a method for hedging risk in investment, it indicated a serious concern over the shortcoming of the current patent system for evaluating patentability of inventions in the information age because the system was developed to examine inventions grounded in a physical or other tangible form under Industry 2.0 and 3.0. Currently, many software patents are invalidated in the United States because of the old standard, which focuses on tangible and physical aspects of inventions. Therefore, the concern indicated by the Supreme Court has become a reality. Another feature of inventions in the information age is borderless. Information moves one country to another very easily. Elements and steps of software invention spread among countries to produce a technical advantage. However, the territoriality principle remains to control acquisition and enforcement of intellectual property rights. In applying the principle in IP rights, each nation should have a freedom to set the requirements and scope of protection. The principle also limits the enforcement of rights granted by the nation within its territory. However, nations no longer have a freedom to set requirements and the scope of protection after TRIPS entered into effect in 1995. Most United Nations members are members of TRIPS. These member states gave up the freedom because TRIPS imposes duties on member states to follow the same minimum standards regarding conditions for patent grants, the scope of exclusive rights, and patent enforcement mechanisms. European countries gave up even more by harmonizing their IP systems through EU regulations and directives, as well as the European Patent Convention. The necessity of removing trade barriers led to a substantial modification on the territoriality principle. Business and innovation reality also led nations to modify the territoriality principle when IP rights are enforced against borderless infringement activities. The U.S. Supreme Court emphasized the territoriality principle in the 1972 Deep South case and refused to find infringement when all elements of the invention were combined outside the United States, even if all elements were manufactured in the United States and exported them as an asset to be combined. U.S. industry was unhappy with the loophole created by the decision. In response to the request from the U.S. industry, Congress revised the Patent Act and introduced 271F to overrule the Deep South decision. Under this provision, act of supplying all or a substantial portion of the components of a patented invention from the United States is infringement of a U.S. patent, even if such components are uncombined in the United States, as long as the act of supplying is done in the manner to induce the combination of the components outside the United States, or the component is made for use in the invention. In short, this section allows U.S. courts to reach out infringement outside the United States and interferes in foreign countries' sovereignty interests. Nevertheless, the U.S. Supreme Court tries to remain true to its precedent. In Microsoft versus AT&T, the court interpreted the term components used in Section 271F. In this case, the patent owner tried to recover damages on all copies made worldwide because the copies were made from software supplied from the United States. In refusing to include software in the abstract in the definition of components, the Supreme Court again emphasized the territoriality principle. The court made it clear the presumption that the United States law governs domestically but does not rule the world applies with particular force in patent law. I reproduced the statement of the Supreme Court in this slide, which gives a great respect to the foreign sovereignty. However, in more recent decisions, the U.S. Supreme Court did not show the high respect to the territoriality principle. The old common law principle of restraints on alienation has the priority over the territoriality principle. Both copyrights and patent rights are exhausted internationally once a product protected by copyrights and patents are sold under the authority of IP owner. regardless of whether such sale occurred in the United States. For the Supreme Court, the policy for securing a free flow of product in the market is more important than the policy of respecting the foreign sovereignty interest to control IP rights they granted. Therefore, the Supreme Court faced a dilemma between the territoriality principle and the business and innovation reality. Lower courts face even bigger challenges for deciding infringement of inventions, where some steps were performed by one party in the United States and other steps were performed by another party in other countries. The courts found infringement if one party controls and directs another party, or these parties create a joint enterprise. Lower courts also need to calculate damages as a fund royalty for infringing standard essential patents. Such royalty is calculated as a royalty resulting from a hypothetical license negotiation between a willing licensor and licensee to exchange worldwide patent portfolio, because this is what the patent owners do in the real business world. Not only US judges, but also UK and German judges began to calculate a worldwide fund royalty rate. Therefore, courts cannot use the territoriality principle as an excuse to ignore business and innovation reality in the information age. The question remains, courts of which country should have the priority to decide the worldwide royalty rate? Currently, it appears the court which decides the royalty first has the priority to apply the rate worldwide. In conclusion, the territoriality principle in the original form has been substantially modified to address the needs of business and innovation reality in the information age. However, even with the modified form, courts struggle whether to remain true to the territoriality principle or extend their power beyond the border to address the needs of business and the innovation community. Because the territoriality principle originates from the sovereignty power of each nation, there will be no easy solution to overcome the dilemma through legislation or international agreements. As a result, contract plays a very important role for eliminating a risk of future disputes, as being highlighted by standard essential patent disputes. More and more technologies are exchanged through worldwide IP portfolio licensing rather than individual licensing to reduce transactional costs and time. To resolve disputes over the license, IP owners may prefer to use arbitration rather than court proceedings because arbitration is also borderless. However, we do not see any significant increase in use of arbitration for IP disputes because IP owners are reluctant to resolve IP disputes through arbitration. This reluctance may result from uncertainty regarding whether key issues of IP disputes, such as validity, are arbitral. With recent initiatives run by major arbitration institutions, more and more borderless IP disputes are resolved by arbitration in the future. It is particularly interesting that the CJEU encourages such initiatives to resolve disputes over standard essential patents. Thank you, merci beaucoup, again for giving me an opportunity to share my thought on territoriality. I look forward to seeing you at the future conferences and discussing this topic. Au revoir.